So this is the due process of law. If you're charged with breaking a federal, state, or local law, you'll be arrested. And when you're arrested, you have the right to remain silent. Anything you say may be used against you. You have the right to consult an attorney. If you can't afford an attorney, one will be appointed for you. And if you decide to answer any questions without an attorney, you'll have the right to stop answering. Next is the booking process. In a booking process, the police officer will write the suspect's name and the crime for which they're being arrested. The police officer will take a mugshot, take the suspect's clothing and property into police custody, take fingerprints, conduct a full body search, check for warrants, do a health screening, elicit information relevant to incarceration conditions, and take a DNA sample. In the arraignment process, a person charged with a crime is called before a criminal court judge. The criminal court judge reads the criminal charges against the person charged. They ask the defendant if they have an attorney. They ask the defendant how they intend to answer to the charges, if they will be pleading guilty, saying they're not guilty, or not saying. They'll also decide whether or not to alter the bail amount and announce the date of the preliminary hearing. Once you get to the preliminary hearing, a judge will decide if there is enough evidence to force the defendant to stand trial. The judge uses the probable cause legal standard, where the judge decides if the government has produced enough evidence to convince a reasonable jury that the defendant has committed the crime. Then, in a pretrial plea bargain or pretrial negotiation, it's the defendant's last appearance before the case goes on trial. And a pretrial negotiation is often used because some cases can be decided without a formal trial. In the actual trial, a jury is selected. Each side, the prosecution and defendant, will present their arguments and evidence for why the defendant is either innocent or guilty. The jury will then retire to the deliberation room so they can talk about the case and come up with a verdict. The verdict is when the jury has just voted on the case after hearing all of the evidence and announces if they found the defendant guilty or not guilty. Lastly, you have the appeal process. The appeals process is when the defendant is found guilty and asks for a retrial because they feel the verdict was not fair. The appeal will only be taken up by higher courts if the courts agree that there's a good reason to hold a retrial. Sometimes, but not usually, the trial goes all the way to the Supreme Court. And that's the due process.
Yes.